So, by participating in the support group calls, you are acknowledging you understand there are no mental health providers or attorneys on this call, and that nothing said here is any way to be interpreted as mental health counseling or legal advice. Brian is an amazing attorney, extremely knowledgeable in PA. I have learned and continue to learn so many new things of what's happening out in the community. I invite you all to visit his website, and perhaps he can give you that. I think it's under Brian Ludmer. He's out of Canada. So those of you that are in the United States cannot utilize him in your case as an attorney. However, he has very cleverly created a consulting service where he can advise you in your case. And I have worked with him as a coach, and he's worked on some cases, and he's actually even recommended family systems therapy. There's a case of a dad who will be joining shortly, I believe, who's having some really effective results from that. But Brian can work with you or your attorney and coach you and consult on your case. And he's done that, and I've worked with him on several of our cases. So highly recommend that. Even though he's out of Canada, don't have it that he can't work with you. Extremely knowledgeable. Many of us have attorneys that aren't very knowledgeable, but he can certainly guide them, and they can do the legal process, and he can guide them on the strategies of what needs to be done. So with that, I'm going to turn the floor over to Brian. The floor is yours, and when you're ready for questions, just let me know, and I'll go into the chat room.
Thanks, everybody, for giving me a little bit of your time on a Sunday night. The topic I'm going to speak to you about today is systemic family therapy for the types of issues that families facing parental alienation dynamics are dealing with. It is obviously something that can and should be tried at some point along the way. But the point I want to leave you with is that a simple referral, you guys shouldn't be in court. Off you go, solve it in therapy, deal with the issues, which is a recommendation you'll hear from judges in every single case, is simply not going to work. The track record for what we call outpatient therapy, it's really a misnomer, standard therapeutic interventions in troubled family systems, fail time after time after time. And the concern is not the fact that it fails and you ultimately have to go back to court for more invasive remedies. The fact is each intervention, each time somebody's talking to the kids, trying to get them on side, trying to get changes in attitude and behavior, and then it doesn't work because no one is invested in the process, it makes it harder to successfully pull off the next intervention. And so for that reason, this is a step that we are always going to be doing in these cases, but it has to be carefully structured, and there has to be a surrounding court order that compels supportive behavior on the part of the parents if the therapist is to have any chance. So I'm going to start off counterintuitively then, showing you judicial pronouncements for all the failures. So let's start with that, because those who ignore the past, of course, are condemned to repeat it. And this is something I'd never seen before, but it became relevant when I was trying to sell this more structured sort of approach for people to see that something less structured was just not going to work, and it was going to waste a lot of time, a lot of energy, a lot of money, and ultimately stand in the way of success. So everybody should be seeing a screen here, respondent statement of law. This is an actual statement of law that I used on a case. It's one of many, many standard precedents that I have, and we just keep updating these. So to Cindy's point, if you're in the United States, the case law that's going to be cited here is Canadian case law. In Canada, we tend to be fairly open to good, insightful case law from out of the jurisdiction, but usually at another Canadian province. But I've used some really good British cases and occasionally an American case as well. That seems to be less acceptable in the United States. So what U.S. attorneys do when they're given the precedent that I'm going to take you through is they'll pull the language and they'll do a word search in their U.S. jurisprudence database to find similar cases that tell the similar story. So it's the thought process is universal. So here's what it looks like. So there's a summary paragraph here up front, and then we get into specific examples from specific cases, and these are all live hypertext links in the document. I'm not getting that pop up here, so oh no, it is okay. So for instance, you should see on your screen, I'm hovering it. There's a link to our public open data set for court cases. Most good jurisprudence in Canada is just available for free on the CanLII website. I don't know if it's too small for you guys to see it, but each of these is a live link to the actual case itself from which the quote is taken. And I'm going to just show you some examples, but there's a kind of a summary paragraph here in paragraph 1. So this is why, in summary, traditional therapeutic constructs are going to fail, not meet their goals. So number 1, traditional therapy based on a therapeutic alliance fails in the case of high conflict family dynamics. What does that mean? The basic premise of all types of therapy, other than systemic family therapy that I'll be describing in the course of this presentation, is that there's this therapeutic alliance between patient and service provider. And implicit in that deal, so to speak, is if you're the patient and I'm your therapist, no matter what sort of training, psychologist, social worker, psychotherapist, etc., I'm implicitly telling you that if you're prepared to let your guard down and really open up and do the work with me to make you a happier person, to resolve whatever feelings, concerns you have, I will, 1, keep it confidential, 2, not push you out of your comfort zone. We'll take it at your pace. Number 3, not judge you. I'll just be supportive. And so it's kind of like this safe cocoon I'm offering you if you're prepared to drop your guard and really engage with me so we can try and solve this together. That's the therapeutic alliance. And all therapy is based on that. Now, think about your cases and similar cases. One parent is unwilling. They're likely to have to be dragged into this process. The child or children are certainly unwilling, and they're going to have to be dragged into this process. And the result that you're looking for, healed relations to equal, healthy, happy homes, meets your goal, but not their goal. They're going to use this process to try and get the therapist on their side to actually back them up in not allowing the family system to heal. They're not going to be willing to be directed to a solution focus to avoid re-arguing the past. Just concentrate on what we all need to agree for a better smoother future. So a traditional therapeutic model where the therapist is not pushing and it's confidential and you wind up with silos where what's said in one session isn't shared with the other person, even though the comment is about them, is anathema to a successful intervention. So what you really need, and this is a piece of rhetoric that I actually had a judge adopt in one of the cases, is all oars pulling in the same direction. The visual is a rowboat where if everybody's working at cross purposes, it literally just goes around in a circle and it never gets anywhere. So in other words, there's a lot of work to do in advance before the therapeutic intervention actually starts. Lay the groundwork for a successful intervention. You'll notice I've stopped using the word therapy. It's more of a directive psychoeducational sort of process. And if that foundation is there, instead of the intervention being a recipe for failure, you got a fighting chance on it actually working. And if it doesn't work, the learning from it and the report the therapist is going to write, in other words, it has to be a fully open process. There has to be accountability. Without accountability, it's destined to fail. So it's part of the structural elements of a systemic family therapy intervention. So this summary paragraph takes some of the best judicial rhetorical comments about why the therapy failed in that other particular case and just summarizes it here. So to achieve success in the repair and reestablishment of the relationships, the power dynamics in the family must be changed. Professor Harmon has a great paper out on power dynamics in family systems. And the favored parent must be completely on board, showing leadership with all of the children having a relationship with both parents. Without a child having permission to change, a therapist can achieve nothing. So, and look down here. Further, the favored parent is likely to sabotage the therapy if the children appear to be softening their opinions of the rejected parent. So these are some of the best quotes, but it goes on and on and on in this document. And in the most severe cases, if you look here, this reference to Dr. Fiddler is Dr. Barbara Fiddler of Toronto, who's widely acknowledged as one of the leading experts in the field, and who was one of the two guest editors of the January, I believe, 2020 Family Court Review that was all focused on parental alienation and remedies and diagnosis. And the consensus in the wrap-up article that Dr. Fiddler and Professor Bala did is that in most moderate severity alienation cases and all severe cases, the traditional therapeutic models are not going to work, are contraindicated, which is a medical term meaning don't do it, it will cause harm. In other words, way more than just ill-advised. And the bottom line, born of years after years after years of therapeutic failure, is that, look at this quote from Dr. Fiddler, the prognosis is poor for reunification therapy being effective while the child remains with the favored parent. So this is the protective separation, temporary timeout remedy. What we're talking about here today is this just a mug's game, or is it actually possible to craft an intervention that stands a decent chance of actually working when all you're asking for is, can we just have peace in the family? Can't the kids enjoy both parents and both extended families? Why is this a zero-sum game? Isn't it win-win-win when the children can recapture these relationships and therefore benefit from them through the life cycle? This is just not how the favored parent is looking at it, and the kids are caught in the middle and usually suffering from all kinds of cognitive distortions and loyalty binds. A systemic family therapy intervention looks at all of those relationships, all of those power dynamics, all of the narratives within the family system, and basically restructures it into a healthy format. So it's important when you're asking a court to force, it's like the famous expression, you can lead a horse to water, but you can't make it drink. If you're asking a court to force the other side into a solution-focused therapeutic intervention, it can't just be that. It needs structure, it needs goals, it needs milestones, it needs buy-in, but most importantly, it needs accountability. A fully open process where the therapist can write reports. Okay, so that is why, I'll stop sharing screen, I started you guys off with a very sobering look at just complete failure. And just in the last 6 months, despite getting some of the tools that I'm about to show you, I think I've got at least 5 cases going on now where the therapeutic intervention was just a complete failure, and for usually the same reasons. Not enough structure, not enough tools, and a complete, utter absence of good faith, solution-focused energy on the part of the favored parent and the children. So, what are these supports? What do they look like? What court orders forcing the parents to act in a supportive fashion should we be asking for? And the answer is in a document that I'm next going to put up on the screen, what I've just built and built and built on for many, many years. It keeps getting longer, but it does get customized. This is just precedent from a recent case that I would use as a starting point. So let me share a screen. So everybody should see the nice branding. Thank you very much. So what this is, the content of this goes in a court order. So it's binding on both parents. It's indirectly binding on the children. And it empowers the therapist or psychoeducational interventionist, pick your label, gives them power over the family system. If people aren't engaging properly and in good faith, the systemic family therapist is going to be pointing to particular provisions where they're obligated to listen and apply and do what the therapist says, or else they're in breach of a court order. The contract between the therapist and the family will dovetail with it. And there's some standard language that was developed here in Toronto that is now fairly pervasive in the different models that the therapeutic community up here uses, that has language in it to make sure that all oars are pulling in the same direction, that everybody's on the same page, that everybody has the same goal. There's an introductory session that says both parents acknowledge and accept that it is in the children's best interests to have fulsome relationships with both parents, that there's no reason why the family couldn't pull it off themselves, but that's why you're coming to me. And that is what is going to happen. That is the goal. Get back to the previous parenting plan or create an equal parenting plan. There's a common goal. So if one parent is saying, well, the previous parenting plan is old and it's quite obvious that the children didn't want to continue to follow it. So we're not, I'm happy to do some therapy, but we're not trying to get back to that existing parenting plan. It's a non-starter. Or if they're saying, well, let's let the therapist figure it out and decide parenting time and whether we can get back to that, that's also not going to work, because those approaches turn the therapy into a battleground of how quickly, too fast, too slow, and nonstop negotiations over parenting time, instead of dealing with the issues that a therapist can resolve and which should free the family back to return to the pre-agreed parenting plan. So if the other side is saying we should leave contact up to the therapist, they'll know when it's the right time. They'll know. Absolutely not. It runs counter to this structure. Parenting plans are given to the systemic family therapist to apply, to support, to get everybody back to, as the goal, the target, to be reached within 6 months, standard term. You don't negotiate that or ask for determinations about that from the therapist. And that'll be fleshed out in the contract itself. So let's take a look at some of these therapy provisions, okay? So you'll see there's a lot of deliberately loaded language immediately, right? Go back to the failed therapy, delay in signing the agreement, delay in scheduling appointments, canceling appointments, etc. Lots of the clauses here that will go into the court order are meant to deal with that game. So, for example, sign her retainer contract on a timely basis. We don't like the pressure because this is very directive. I never thought that she'd be pressuring me to have the children go back to their mother's house. I didn't sign up for that. Well, look at this clause. Subject to court approval, neither party may terminate the service, because the favored parent is likely going to be put in an uncomfortable position. They're going to be disempowered. They don't like that. They're going to resist that. This is not standard feel-good therapy. Same thing for the child. People are going to be asked to leave their comfort zone, including the targeted parent, who often is making certain mistakes. There's no such thing as a perfect targeted parent. There's always mistakes being made. The difference is that targeted parents are like an eager student. Tell me what to do. Tell me what to stop doing. Anything. I want to reconnect with my child. Conversely, a lot of the work has to be with the favored parent to get them out of their comfort with the other parent being somewhat cut out of the child's life. So, what about the children? Can the favored parent, hi, but it's not me. I don't think the kids like the therapist. Well, look at this clause. Both parents shall use their parental authority to compel not just the children's attendance, but good faith participation until the services are completed. In other words, the kids need to know right at the beginning, this is a solution-focused process to get you back to parenting plan X. A classic therapeutic mistake is to bargain with the children. And I had one recently that was a failure. It was a team approach with one therapist from the organization working with the parents and the other one working with the children. And the therapist made the eldest child a promise that she wouldn't be forced back to the previous parenting plan. So it doesn't take a genius to figure out that the family never got there. Just an absolute breach of professional standards. Okay, paragraph 3. The parties shall equally pay the family therapist's account on a timely basis to ensure continuity of services and fund the retainer. Isn't that self-evident? Yes, but is delays in payment causing a slowdown in services, a lot of wasted energy, a cause of therapeutic failure? Of course it is. So we draft against it. And notice it says the parties shall equally pay. Very often you'll have the favored parent saying, well, I'll agree to it, but only if the targeted parent pays for it. After all, they're the one benefiting from it. Well, that warning sign should go off there because that means the favored parent doesn't have any skin in the game. If the favored parent is also paying per service, then they're highly incented to have this thing achieve its goals as soon as possible. If only the targeted parent is paying, that financial incentive is not there. Okay, paragraph 4. The individual therapy being conducted by somebody shall be suspended, or if it's continued, it's subservient to the reunification therapy. Very often, favored parents have even jumped the gun, and even though we're talking about a relational problem, they're just looking to garner evidence, and so they'll take the child to an individual therapist, not to talk about school bullying or general anxiety or you name the individual issue, but to dish about the targeted parent. And what happens, remember the therapeutic alliance, what happens in individual therapy reinforces. We're not trying to change the person's views. We're not trying to be directive. We're just trying to make the person feel good. Well, what's the easiest way to make a child who doesn't want to see a parent feel good? Oh, Johnny, I can understand completely the anxiety that you're expressing to me. And I agree, you shouldn't be forced to see your mother because you're very anxious about it. So it can be completely destructive. And there's nothing new here. We've known about the destructive effect of individual therapy if it is running counter to the goals of the family therapy for a very long time. There's an article that is now 21 years old that I keep recommending to everybody, a 2003 article from the Family Court Review titled, "Is the Child's Therapist Part of the Problem?" We see this time and time again. So clause 4 is very important. So now there's a little bit of belt and suspenders. Here's paragraph 5. Parties and children shall fully engage in good faith with urgency and with a view to the successful reconciliation of healthy and involved family relations. Of course, that's defined in relation to a particular parenting plan. So we don't want Johnny showing up at the therapy and then just sitting there with his hands across his chest and There's not going to be any movement from him. He's just here marking time. You might as well not come. Engage with a view to solutions. What does that mean in practice? Paragraph 7. So families come in, they have certain narratives, why things are broken down. And the favored parent and the kids, they're going to hang on tight to those narratives because those narratives give them power in the family system. The minute they surrender those narratives, they're going to have to loosen up and go back to the previous parenting plan. So they don't want to give up those narratives. They want to prove that mom sexually abused them, or dad is a yeller and is unreliable. So it's a non-productive process. The therapist is coming in 2024, and people are saying in 2018, he did this, she said that. You can't do anything with this. And you're trying to teach the child how to have intimate relationships in future, how to have friendships in future. You can't hold a grudge. You can't lord it over somebody that your perspective is correct and they're lying. You have to be prepared, and we teach the kids this, that it is possible for two people to mean well, participate in some interaction, and experience it completely differently. They didn't mean what you're interpreting them to have said. That wasn't their intention. That wasn't their meaning, for example. This is an important life lesson that we're teaching to get them past this. So the rule, because this is a basis for perpetual failure. So the rule that I came up with here in paragraph 7 is that leave the past in the past. The past is relevant as the source of the topical matter that the family has traditionally had difficulties with. And you spend your time not debating who was wrong, who wasn't perfect, who forgot something about the past. You just say, and I'll pick kind of a silly example, bedtimes, controversy over bedtimes. One house, it's okay, play Fortnite till 2 a.m, no problem if you're exhausted or you get to school late the next morning. The other house, more structured, child caught in the middle. Guess which house child is going to favor? Race to the bottom of permissive parenting. And we need the family to say, there's been controversy over bedtimes in the past. How are we going to do bedtime better in future? Not going to debate the past. We're just going to say we anticipate bedtime will be an issue going forward. What's the plan? What's the new family constitution? Can it be 10:30 at dad's house and 9:45 at mom's house? And the child, that's a small enough difference, the child can tolerate it. And mom compromised a bit, moved it a bit later. Dad compromised a bit, moved it earlier. And what we're teaching children along the way is conflict resolution, compromise, meeting an important person in your life halfway. So there's a broader skill set that they pick up. And when you start solving these individual issues, one after the other, it builds confidence and it makes all these relationships more resilient. Now, if things are not working well, the family therapist got to nip it in the bud, start to set some rules, give some directions, have calls with the attorneys, say, hey, I'm not getting the cooperation I need from your clients. And so I've got a bunch of clauses here that deal with that. And often we have tribal warfare, so the problem may actually be with the grandparents or the new partners. They can't say I've got nothing to do with that. The parent is obligated to ensure that the extended family member participate. So those are going to be court orders. They're effectively parental covenants to support the therapy. But then in addition, we want general good behavior covenants. Some are phrased positively, well, like what I call positive covenants. You will do this, you will do that. Some are phrased negatively. You won't do this, you won't permit that. And so there's a lengthy list of those, including the positive covenants, the ones where I'm forcing you to do something that you might not otherwise do, are more important than the negative covenants. Everybody knows about speak wells. It's very hard to enforce unless the child starts repeating some of the pejoratives. But it's easy to enforce the duty to positively promote the other parent. So you'll see, and I will send to Cindy to send to you the various documents here that I've been putting up on the screen. But paragraph 14 is something that I started to develop over the last maybe 5 years. Because remember I said that narratives yield power. And whether it's completely fictional or just grossly exaggerated, or there's a kernel of truth, but it's kind of been twisted and distorted, or totally true. It was just an inexcusable, there's no such thing as an inexcusable mistake. It was an unjustifiable mistake. Person apologizes. Apology must be accepted. That's part of interhuman relations as well. And you move forward. It doesn't really matter which one of those it is. Its very presence is going to interfere with the healing. And so we take the particular legends and narratives in the particular family system and we prohibit them. They're done. Right, wrong, partially true, partially wrong. It doesn't matter. They're not to be raised again. If there's a concern on a topic, there's going to be a go forward rule in our family constitution. But you will stop the categorical statements, the historical statements, because they're highly damaging. Okay. Again, this precedent, very, very thorough, goes on and on and on, all about positive and negative covenants. And then something else right here at the end, we have what's called the Canadian Charter of Rights. So I developed the Children's Charter of Rights. So the children have certain rights, the right to love both parents, et cetera, et cetera. The parents are obligated to respect those rights. And the children have certain responsibilities, which are the mirror image of the rights. So that's this document. It's very thorough, and it's meant to create for we'll still call it a therapist, the platform and give them the power and the tools over the family system so that they can be successful. Remember, odds are against us because we don't have willing participants, But if we can structure this right and have the appropriate foundation, we've got a good shot. And that's the best we can do in these very difficult situations. Okay, so there's going to be a court order, there's going to be a contract, there's going to be these covenant patterns, and we are going to be wary of doing this on an unstructured basis. Is there anything further we can show the court so that the court can understand how this is done and how this differs from the typical therapeutic intervention? And the answer is yes. I've mentioned the phrase systemic family therapy, looking at the family as a system. And again, there are a couple of people have been posting in the chat, yes, everything I'm showing everybody, I will send to Cindy to send to you. So the therapy itself might be resisted because it looks like it's really thorough and is going to possibly work. And so they'll fight you right in the motion. They won't agree to the therapy, the other side, and they'll fight you in the very motion where you're seeking to get these court orders. So how do we get past that? Well, we get past that, according to our law, by pointing to the law that says that this is something. It's one of the few tools available to a court short of a trial, and we always try and avoid trials, to fix a family system. A court is not well placed, and it would take too much time for the court to play the role of therapist and start to make a million determinations of who said what, possibly indirectly, possibly wrongly. Maybe the child was misled on this. I mean, that's a lot of detail work that a court just doesn't do. So the whole idea is get them into family therapy as a solution for parent-child contact problems, because the court is not well placed to deal with a lot of these nuances. So in our law, this is something that a court can do, and can do even over the objection of the child involved, because it's rare that a child not seeing a parent is going to say, sure, no problem, let's go into therapy and try and solve it. Some courts, though, are a little bit reticent, and they need more help in terms of what it is that we're actually talking about. And so they've said, I'm not just going to order therapy in accordance with these buzzwords. You need to show me exactly what you have in mind and why it's going to be helpful. Sometimes that's disappointing because of the fundamental reasons that it's an ancillary power that courts have over family members, so long as the children are minors. And, well, what else are you going to do, Your Honor, if you don't order this therapy? Then what? We go into a hearing where you have to find fault with a parent when the background is quite complex, and the parent is going to hide behind, it's not me, it's the children. Why don't you see if we can fix this? And the therapist report will help the court if a compliance motion is required in future, because the best way to tell whether someone is complying with their obligations as a co-parent is to see if they participate fully and in good faith in fixing it in the family therapy. If they don't, if their true colors show through in the family therapy and they're not complying with that whole list of parenting covenants, now a court's in a position to find somebody in breach of court orders and do what they need to do. So if I'm going to show a court what family therapy is, I can do it the hard way or the easy way. And guess what we do. So this is what I'm now showing on the screen. This is my firm's recently updated family therapy library. All of these textbooks. And it goes on and on and on and on and on in terms of the science of systemic family therapy. I'm up to 74 volumes. Or you could pick some particularly good peer-reviewed journal articles or chapter in a book. And here's one I would recommend. This is a chapter by Shelley Pollack, who's a well-known therapist here, and John Moran, who's another clinician. It's a chapter that describes how family therapy works and what the issues are that they struggle with and what the goals are for the participants. There's some objective measures of health in the family system, etc. And highly recommended. So I'll make sure to send you guys this book chapter. So this is one way, but it doesn't really work well with judges. They're just not well placed to receive a bunch of science and know what to do with it. So the best thing is to come in with an expert report on a non-case specific basis. Caitlin Burgess is one of the best I've come across, and she's out your way in California and Washington. And so this report was crafted for a file that I'm consulting on in Detroit, where there's a failed therapeutic process going on, in large part because the therapist really doesn't know what he's doing. And we need to educate the court as to how systemic family interventions are done. So here's a 6-page expert report that is crafted as a mini textbook for what this is all about. But the failings of that particular therapist, which is why that particular family is getting no benefit from the therapeutic intervention, are built in here as errors. We made sure to cover not just the breadth of how systemic family therapy for conflictual family systems is done, but also to cover the particular errors that were going on in that place. So your motion, if the intervention is not just on consent, would benefit from something like this, a non-case specific description of what the process is all about, what the goals is all about. And what Caitlin does here is she adopts a list of parenting covenants very similar to what my firm precedent is, also telling the court that if you want this to work, you have to empower the therapist. So that's how you get an order for systemic family therapy. And it's also good if both sides and both attorneys read this so that they know what it is they're getting into. So now, what are some of the things that can go wrong, even in a properly structured systemic family therapy intervention and with an experienced therapist? So I'll start off with whack-a-mole, which hopefully, often these days I'm dating myself, but hopefully everybody is familiar with the game of whack-a-mole, the kind of carnival game. And so what you'll find is the therapist takes their time learning the family, meeting with the parents, and then finally you get a therapeutic session between the child and the targeted parent. By this time, the therapist has had a couple of sessions with the targeted child to soften him or her up and make sure that they understand the mandate is solution focused. And so you'll have this session, and obviously the child's going to want to start off with the three biggest grievances. And where this is artificial, those grievances will just dissipate like a dream, just vaporware, the minute focus and discussion is put on it, because there's no meat or merit to it. And so in one particular case I had recently, in less than the full hour allotted for that session, all three of the most important issues disappeared the minute the two parties, child and father in this case, were in the same room, and the father had a chance to address with the child, not indirectly in a silo where what he has to say is sent to the therapist translates it to the child, and then translates the response back. It's too cumbersome, it doesn't work, and it doesn't really put the child on the spot. If that's what you're saying, back it up. And there's usually no backup because, as we know, children are suggestible, etc. So in this particular case, they're 45 minutes in, all three issues have been dealt with, and they got 15 minutes left, and they have nothing to talk about. It's like, okay, well, that was easy, got that solved. Are you coming back to live? So they schedule another meeting to just make sure that this is all great, everything's solved. But the child comes back in with 6 or 7 new issues that either the father hasn't heard of before, or it's some ancient thing that predated the current controversy and breakdowns by like 4 years. It clearly has no merit. It's like whack-a-mole. You deal with 3, another 5 pop up. When you see that, you know you're dealing with an artificial process. And in this case, the child was going home and the mother was arming the child with the next several things to say, etc. Eventually, what happened was the father was able to catch the child in a direct, objectively proven major lie. And you could see the therapist finally clue in that there's been a year of nonsense, that there's no merit, that this child is simply advancing somebody else's agenda. And at that point, the therapist wrapped it all up and said, we're ready to go back. Here's the build-up schedule. We're going back to 50-50. And that family has been smooth sailing ever since. So what happened was the therapists need to be firmer with the children, to think forensically, to start with the assumption not that the child is telling the truth, but the assumption that both parents agreed on 50-50, and was 50-50 in this case for 10 years before it fell apart. I'm sorry, it's not likely to be legitimate. And so you need to just not buy into the child's narrative. Child's got to prove their narrative. Too many therapists say both parents are lying. I believe the child, when that's a terrible approach to take. It's not evidence-based. This is a solution-focused process of crafting a future parenting plan that will run smoothly. You're not aligning with anybody. The therapist's job is to achieve the result. Some of the other things that can go wrong is it's a bait and switch. You're lined up for a compliance motion. You have the other parent in your sights. It's obvious that they've been breaching the parenting plan. So they say, well, instead of litigation, let's try family therapy. But they're never really invested, just a delay. It's a bait and switch so that you lose your spot in the court process. You need to always, if you want to keep accountability, keep a pending court date, even if it's only for a case conference with check-ins as to how the therapy is going and a written progress report from the therapist. Accountability toward the common goal. You must have a common goal. You have to have milestones along the way. Can't be very little contact, but we're talking it through in therapy. And then finally at month 5 with a 6-month end goal, you start to talk about getting back toward a parenting plan. Is not the way to do it. You should, as you deal with an issue, parenting should resume. Relationships have quid pro quos. I make a compromise. You're going out for lunch and a movie with me or lunch and shopping with me. And we just keep building from there. You could have a parent justifying improper behavior from a child. And when you see that, they're not in alignment with the goal. Therapists need to be firm and directive. If not, they may understand what I'm talking about here conceptually, but they're not going to be successful. So you need the right therapist who's prepared to be directive, who views it as they're receiving an assignment from the court to take a broken family system and have it completely fixed by month 6 or on the verge of being fixed, and to give progress reports to a court that is supervising it. When you do that, build on the foundation that I showed you, you have a decent chance. You need lots of check-ins. There'll be roadblocks. There'll be miscommunication. So the attorneys need to be actively supervising this instead of just, okay, it's out of the legal process, it's into the therapeutic process, checking with me if you need me. It is not a good plan because these family systems are very fragile and the process can be saved if you jump in at the earliest signs of potential failure. Okay, now, so what else do I have to show you here in this folder? I'd love to show you a genericized report on therapy, both the successful report and the unsuccessful report. But that would take some doing. But the next time I give this sort of presentation, I think I'll do that. I do have a PowerPoint presentation that I gave to a group of therapists that you may find interesting as well. It covers some of this as well as other topics. So I'll take a look at that, Cindy, and see if I can include that as well with what I send you guys. And I think given our time tonight, I'd like to leave a little bit of time for questions. So I'll stop there. It's a fascinating topic. I have, on behalf of my clients, supervised and participated in hundreds of these interventions. So, and with that list of textbooks, 74, I can't believe I'm up to 74 now. I really do understand systemic family therapy. And when it works, it's an amazing feeling that you saved a child or children. So that's this area. So, Cindy, I'll take some questions.
Well, thank you, Brian. And I would just like to say that there's several cases that I have worked with you, and some of those parents are working on the family systems therapy right now. And one of the things I would just like to remind everybody of, having been through multiple different reunification therapy programs with my own children who are now aged out and they're out of the system. The failure was that there was myself and my children in the therapy, and never was the parent who was aligned, who was manipulating everything in the background. So I was always, they were coming in and I was always just getting punched, and then I was just dealing with the punches. So I really find this family systems therapy to be an amazing new idea. And the cases that I'm working with those parents on right now, I'm seeing some amazing results, because what you do is you bring in the aligned parent, and now it's not just focusing on you, it's a family system. And like Brian said, there's always that narrative, and now everybody has their narrative, and then that can be dealt with directly, and it is extremely powerful. And I'm seeing it firsthand. So I thank you for that. And those cases are people who have already consulted with you and already in that process of dealing with that. So let's go to our questions. Um, let's see, what is I'm going to say findings instead of assessment, because judges will get findings necessary to be able to get structured systemic family therapy ordered by the court. Then how would someone get that assessment ordered by the court? Okay, so say that's the question.
Okay. So if you're going to court, it's because your family system isn't functioning, there's contact problems, there's controversy, children are being rude and objectionable, and they're clearly under stress. It's one of the best tools that a court has, because the alternative is they got to make some ruling that somebody is undermining a parenting plan, which sometimes is not easy to do. So this is one of the best powers that a court has. And people should enter into these on consent, but if you had to litigate it to get this, you have to identify aspects of the child's behavior that are problematic and damaging and can be resolved through this sort of process. And the rest of it is just the logic of making these arguments.
Something I would like to contribute to that, Brian, in what we saw here in the United States was in asking for is that the parents asked for the family systems therapy as the resolution. So to have the attorney go in and identify whatever the circumstances are, there did not have to be a trial in this, and there was not evaluations in these. But the fact that the parent was willing to ask for family systems and include the other parent makes it more palatable for the judge to order that.
Well, I would even go further, Cindy, to say that, I'll circulate Caitlin's non-case specific expert report. But this only works if you have all members of the family system involved. And sometimes, as you saw the clause, you have to bring in the new partners, the grandparents, because they're part of the problematic dynamic, or there's allegations that kids don't like them and you're trying to resolve it. So just the targeted parent and the kids pathologizes the targeted parent. They must be the problem. So it's a family-wide fix. You don't even start this unless the favored parent is going to participate as well.
Yeah, exactly. And that has been miraculous in watching that, because I was in the reunification for years and years and years and had no result with my children aging out. So I highly recommend to everybody, this is a new solution to bring in the other party. And that being said, I want to say to targeted parents, one of our greatest fears is that what? I'm going to sit in a room with the other party. He's going to be attacking me and we're going to work anything out. I want to tell you that unless that party is in the room, we're not working on anything. We're just spinning in circles, which is what Brian talked about earlier in his presentation. So bringing them into the quotient requires us to be able to regulate ourselves and be eloquent and be, I'm going to say, therapeutic parents. That's Karen Woodall's work. And it does require us to be able to manage ourselves inside of those circumstances as well. But that is work that we must do no matter what in order to be able to reconnect with our children. Now, the next question. My attorney is suggesting we need parental evaluation as the first step in our situation of parental alienation. Is that the best path?
Okay, so you'll often hear people say, there's a medical term, diagnosis before intervention, or prescription. Um, an assessment process, custody evaluation process, I think is the US term, is inherently a divisive process, right? It's all about blame, and causality, and they take a long time. And during that time, the children's behavior is going to deteriorate further. And 99 times out of 100, one of the remedies that comes out of the custody eval is the family should have family therapy. So I these days, unless there's some major threshold clinical issue, or you cannot get the family to meet the intake criteria that I mentioned, I avoid the custody eval stage for the primary reason that I said, that it is really quite an adversarial process. And it's going to leave things worse than they are, and it's going to be really terrible while it's going on. So I much prefer getting right into a solution-focused process. And that's my view of assessment. So if you don't qualify, or what some Canadian therapists do is they do a shorter intake assessment procedure called a clinical intake consultation to learn just enough about the case and the participants to get a sense of whether their process is going to be successful or not. And if the family can get past the CIC and into the therapy itself, that's great. If the family can't, well, then you know that you're going to have to go the litigation route and or the custody eval route and then litigation, because therapy is not going to be an option. So it can also be informative as well as curative.
Yeah, and if I could add to that, when you do an evaluation, you take the risk of finding a evaluator or getting ordered an evaluator, or your attorney is suggesting an evaluator who is not knowledgeable about PA, who will start with the narrative of the child and buy into all of those false narratives, and then the report could center around that. And I say that because that's exactly what occurred in my own case. Okay, so next question. How do I know if my lawyer is capable of navigating parental alienation?
The reason why PA is so difficult is that it's counterintuitive, and many of our leading practitioners have written about that. And to really understand it, you got to understand the law about it and the family dynamics aspects of it and the feelings aspect of it. It takes kind of like a multidisciplinary knowledge. Those of us who have practiced extensively in this very difficult area eventually develop a really good pattern recognition sense. It doesn't take me long to figure out what's going on in a family. But that comes after years and years and years of intense focus. So if you have a more broad-based practice, you may be a great family custody and access litigator, litigating the financial aspects of these files, but really be lost in a PA dynamic. And that's where the consults that I do come in, because if you have a really good local litigator, then they just need somebody providing that extra bit about PA that very few attorneys are capable of doing. It's like a decade of study to really get to the point where you can make a difference. And to support what Brian just said, as I stated earlier, I have worked with Brian on a few cases, and that's exactly what happened. And the other thing I want to remind you of is that many of us don't have unlimited resources. So to change attorneys is extremely costly. And I'm going to say anywhere from $20,000 to $30,000 to switch attorneys. And even then, you're not certain that they're PA knowledgeable. So I highly recommend, when I coach parents, you have an attorney, how are they open to working with somebody? And quite often I'll meet with them and then I'll get them a little bit introduced to PA, and then we'll introduce somebody like Brian. And quite often we bring Brian in and say, can Brian be their coach? And then he can coach on the PA journey. And then you're just paying a very nominal amount of money to have people coaching your attorney who you've already spent endless amounts of money to be knowledgeable on your case, versus hiring an absolutely new attorney who's going to cost you 10 grand just to get up to date on your case if you're into it for a year or so. So that's where having strategists and coaches and all of that comes into place. And it's an additional nominal expense, but it gets your case that's gone off track back on track. The challenge with that is massaging the attorney into being willing to work with others. And it's a strategy that you have to develop, but it is possible. So, and I wouldn't suggest you just show up tomorrow with your attorney and say, hey, I need you to work with this person and that, because they have it that you're asking them to take second chair. And they have to recognize they're going to be in first chair, and you just have some experts that you really feel that would offer something to the case and give some insight. And so it's a matter of how you're going to package that to your attorney to get them to work with it. But that has been very successful, and it is extremely costly to completely jump boat with one attorney and go to another. And you take a risk. Is the next one any more knowledgeable? So next question, would it be possible to have Howard Hurwitz
assess our situation, report his findings to the judge, then have the judge perform a judicial interview. This is a child protection court. Child will be 16 in June, severely alienated. I have ample evidence and strong collaterals, including intake and reunification recommendations from Dr. Fiedler, which I know is on one of your documents.
I know Howard well. He'd be great from that perspective. The real question is what I mentioned before. Do you need an assessment? Is an assessment the right thing at that moment in time? Are you seeing your child at all? Because it's very hard if the assessor can never see you just parenting your child. How are they going to assess your parenting? There's a whole bunch of considerations. If part of the question is my assessor PA aware? Yes, when you're vetting assessors, you need to know, are they open to the clinical possibility? Do they come with biases that children are always right and that PA is very rare, which it's not. It's actually very common. In Howard's case, he's done the Family Bridges training, so he's very knowledgeable in the area. You have to make those inquiries. If there are concerns about mental health issues, etc., maybe you want a psychologist, because social workers will refer the family off for psychological profile testing, but that just generates clinical possibilities, not confirmation. If a psychologist is doing the whole family assessment, then they're going to bring that more detailed knowledge of personal pathology to bear as they're looking at the systemic family environment. So a lot of thought has to go into not just whether, but also the timing and also the selection of the assessor.
Okay. And I suggest to that person that you might want to have a private consultation with Brian to discuss that further because then he can understand a little bit more about your case. So next question. Do I have to go through, I think we talked about this earlier, but I'm going to ask it anyway. Do I have to go through parental evaluation or can I go directly to the motion for a plan like what Brian presented? I assume parental evaluation is necessary unless my wife agrees, correct? And before you answer that question, Brian, what I would like to just state about that is there's kind of a theme I'm seeing here, and that is that attorneys are quite often ordering, or judges will want to go, let's do evaluation. And Brian already spoke to that, but I'm going to let you answer that one a little bit more directly.
It is not necessary to get a family evaluation to just go to court and get a compliance order or to go to court and get a therapy order, or to go to court and get make-up parenting time as a discipline on the process. They take time. They slow the case down, and judges are well aware of the issues in families and what good behavior looks like and bad behavior looks like. So sometimes an expert report just sounds like it's a bit of a crutch, but an expert report is only as good as the factual input to the expert. And then quite often, of course, it's not binding on a court. And sometimes you then run into, well, court can't really rely on it till the therapist or the assessor has been cross-examined. And now you're into yet another layer of procedures. And then how do you deal with all of that? It's now a massive the report, the assessor's file, the cross-examination transcript. Where does that get deployed? Not in a 1 hour motion. So sometimes simpler is better. And you go to court to enforce your parenting plan. We have lots of case law that tell us that what the duty of a co-parent is, guidance, boundaries, incentives, and consequences, progressively deployed, etc. So, I personally feel sometimes too much emphasis is put on custody vows.
Thank you for that. And what I will state, I had two of them in my own case. The first one was 30,000, and the second one was 15,000. And the short version of it was right on, and that person in a half a day meeting understood exactly what was needed and had recommended family bridges. In my case, unfortunately, other circumstances came up, and that judge refused to order that. But it's a lot of money to go into evaluations. So you want to think twice about that. And then the challenge is, if you're going to spend 30 to 50,000 on an evaluation, will you have money left to even do the therapy? And then you're paying for all the legal fees to even get there if you have to go to trial on it. Typically, if you're going to go evaluation, you're already in trial. All right, next question. I'm about to start reunification counseling for my 16-and-a-half-year-old son who has been living with his father for 8 months. The counselor asks I complete the following sentence in her form. The purpose of therapeutic services is, and I can speak in audio about this more, but we're not going to open it up for audio. So what do you suggest that completion of that sentence be, is the question.
Okay, so that is the goal. What I'm going to do is I'm going to share screen briefly here, because remember I mentioned to you guys that supplementing the family therapy and parental covenant pattern that becomes part of a court order is the therapist contract, and they work together. So here's a really good one that I'm now sharing screen with. And you may recall I told you that at the outset of this agreement, paragraph 3, like why are we here? What are the goals of this? We all have to be in alignment with the goal. So you'll notice, aside from some general comments here, look at 3B, the most important one, which I'm assuming is very similar to the question that is being posed. Your goal generally is to return to the parenting plan in our separation agreement, to return to the parenting plan in our consent court order of 2 years ago, etc. Rather than, as I said, this process is not designed for the construction of a parenting plan. It needs a common frame of reference. It needs a common goal. So you'll have these more generalized statements, which is important. Look at this one here. Just think about whack-a-mole there. To correct the child's distortions and replace them with realistic perceptions to reflect the child's actual experience with both parents. To assist the child to differentiate self from others and exercise age-appropriate autonomy. To stop the parents from being overly negative and critical. This is a well-thought-out agreement from a fantastic therapist in London, Ontario, about 2 hours west of Toronto. And hopefully that answers your question.
So, Brian, with your answer now, I have a question. We've had a highly knowledgeable expert in California. I know you know her name, but she doesn't like to be publicly named, so I will not give her name. However, if you want to know her name, I'll at a later time share that. So one of the things that she has presented to our group is that and she's a therapist here, a Family Bridges trained, and she says that when you go into therapy, that you have to look at it as not looking at changing the child's narrative, because you have to see it as irreconcilable differences and look at beginning where you are and how are you going to build that bridge moving forward. Can you just speak to that for a moment based on that? Because many parents I know spend a lot of time wanting to change our child's narrative, and that can be very challenging.
Right. I approach it in the way that I said earlier. We're not asking anybody, we're not debating the past. We're not trying to figure out who was right or wrong about the past. We leave the past unreconciled in the past. We turn our back to the past, we look to the future, and we say, what rules, what expectations, what environment do we need to craft now to apply for the future to make this a smoothly functioning separated family structure? We know what the topics of dispute are likely to be. We need rules about those. We need generalized rules of proper behavior. We need kids being kids and not being over empowered. So we have to deal with a healthy family system as hierarchies and boundaries. We generally put in place a rule that only good news travels from one house to the other. And that's basically it. So that's something you can visualize, something practical. The therapist, Cindy, who gave your client that other language that you read, it's a bit too vague to do anything with it.
Well, so now that you just gave your answer, I do see something in what you've said and what they've communicated, because it was more than just that information. And actually, it
Okay.
was a presentation to our group. So what I see in this now, to clarify it, is that we and in earlier in your presentation, we need to understand what is the narrative, and then we need to address the narrative, because we can't just ignore it and pretend we're going to move forward and get anywhere. So we have to address the narrative and then create a new relationship moving forward once you can get through what that narrative is and what
Well,
the real reality in that is.
what I do is we don't really address the narrative, because that's going to draw you into that debate about the past. We identify the topic that created the controversy from the narrative. We ask everybody to just forgive each other, wipe the slate clean. The clause that you don't have in front of you now says the therapist is responsible for conducting a future focused process, but informed by past difficulties. So we remove all the narratives, because narratives give power and stand in the way of healing. And we say, what are the topics? Not what happened, who's right, who's wrong, whatever. What topics would you like to see handled better, differently in future? And let's talk about how we're going to do that. How are we going to manage that topic in future? And then the narrative becomes prohibited at that point, unresolved, but buried in the past.
And so I just heard the key word there, and absolutely, is the forgiveness. Say you address it, and the forgiveness is where you begin from. And then you have a clearing to move forward into creating something new.
We
So
recognize everybody has an interest, even the process has an interest in not debating the past. Okay? We can both agree on one thing. Going back to the kind of somewhat light and silly example I gave you, The family has not handled bedtimes properly in the past. That's non-judgmental. Everybody can agree on that. But we don't go any further into that narrative. We recognize it's been an area of concern. Now, everybody's forgiving each other on that topic, and we're focusing on how are we going to handle that topic better in future. Everybody's ego is protected. Nobody is ground down. We haven't wasted a lot of time debating about the past. We've just identified topics, and this is what seems to work.
Yeah, and key to what you just said is when you dig into the past, you will spend all of your therapy digging in the past and go absolutely nowhere, but just digging your hole deeper. So thank you for that. And I'm so glad that we discussed that because I think that brings clarity to me. Anyhow, I hope it brings it to everyone else as well. So next we have, and I'm not sure what this is intended from. I'm sure it was written throughout the conversation. What if the other party refuses? And I'm just going to add to that. What if they refuse to participate in family systems therapy? Or
Well, that's why you're getting a court order. Whether they like it or not, this is what they're doing because the court thinks it's the right thing for the family to do at this moment.
okay. Next question. Thank you so much for the presentation. And the question is, how do we find knowledgeable family therapists? How can it be done online only if we do not live in a big metropolitan area?
Okay. So the you start a search for referrals, etc. Um, if you there's a trademark um, of a national U.S. organization, LMFT, Licensed Marriage and Family Therapist, and it's actually a regulated term in some states. There's a Canadian chapter of it, but it itself is not a regulated term in Canada. We regulate the work, so to speak, but that's not one of the identified regulated terms. Regardless, that organization has thousands of members across North America and is a good place to start for this sort of work. Psychologists, just as an example, even though they obviously are real bright and have many, many years of schooling, they're actually trained in individual pathologies as opposed to relational matters. They pick up their expertise in relational matters experientially and by attending conferences, and they're quick to pick it up because it's all built on behaviors and they're very good about behaviors. But the interrelational aspects of human dynamics is not frequently a major topic in psychology departments. Whereas LMFTs, I think it's like a 3-year course of study with a specified curriculum. It's all about relationships. So start looking for LMFTs. They may be social workers, they may be psychotherapists, et cetera, et cetera. Um, and you may find one. If there's nothing in your local area, um, here's what can be done remotely, and we're a lot more comfortable with remote therapeutic work because of COVID. Dealing with the parents over Zoom or Teams, you can get a lot of work done. Um, Less so with the children. That generally has to be done in person. So there may be a little bit of travel involved, but the kids are worth it. And one thing we do where there's some distance involved is we tend to do intensives. So, in other words, there's all this prep work and Zoom and telephone calls and stuff where you're starting to set the groundwork, understand the issues, bring people together. And then instead of an hour here, an hour there, which you can do when the therapist is in the same city, weekend blocks are planned. So a lot of prep work, a lot of Zooms, a lot of homework, reporting back on how it's going. And then the therapist and the family come together for a Friday to Sunday night intensive, nonstop sort of thing. And you might have one of those every 2 months. So there's some people who think that's even a better way to do family therapy, even if you're in the same city, because so much is lost in between appointments, you lose momentum. Um, so the intensive model um, should solve any distance problems.
Okay. So I'm just gonna comment for this next parent. I'm sure it was regarding a previous question, but it says that the other parent was BPD, if that helps with regards to the comment. And I just want to say that typically parents who alienate severely, moderate to severely range, typically have a cluster B personality disorder. So, and Brian's already well aware of that, and that's typically who we already know we're dealing with. So that's all I'm going to say about that. So what to do if you are in co-parenting family therapy and favored parent refuses to let go of the past, move forward, and the therapist believes children are not ready for therapy due to disengagement.
So this is one of the problems we ran into with the therapist in the Michigan matter that I'm dealing with. Children, unless there's something identified at the outset of the process, the children are deemed to be ready. Never quite understood, I'm not ready for the therapy yet. Unless there's some medical issue or something like that, ready simply means that the children have been informed by both parents that the family has been ordered to do this, that both parents are in agreement, that this is going to be solved, and that the children's, if you recall the language of my covenant pattern, good faith, urgent participation in a solution-focused fashion is expected of them. It becomes a parental directive. If they're not, quote, ready, quote, whatever that means, it means one parent has not prepped the children properly, and you're declaring a therapeutic failure because one parent, the favorite parent, hasn't done their job, hasn't complied with the foundational principles that are necessary to make this a success. That report goes to the court. The court orders that parent to fix the problem and get the family back into the therapeutic process. So that wouldn't be a conclusionary report. That would be kind of an interim report to the court from the therapist saying, look, this child's not engaging. I can't get through to this child. I need the favored parent. It's their child. They got the influence. I don't. I got the influence over the favored parent because of the court order and the court supervision. So till that happens, till this parent has the child get with the program, I'm not going to be of much help. And so I suggest that the family go back to court, have a case conference, talk it through, and have a judge reinforce what's necessary to make this a success.
Okay. So to what you just stated, there's a case I'm working with right now. The court ordered the family systemic therapy. This is a parent that you worked with, Brian. And he was able to get that just on an RFO in California, and they've already commenced that. And prior to commencing that, one of the things that I coach this parent all the time, and one of the things that I suggested that he'd get is that to ask, and the mother got to suggest the therapist, and he had to pick from her choices. I see he's put himself on camera now. Um, so one of the things that we asked was we wanted a therapeutic plan, and then that he wanted a report, a monthly report, because the judge ordered 6 months or as the therapist deemed necessary. So, and mom balked at it. I'm not going to pay for that. I won't pay for that. So dad said, I'll pay for the monthly reports. No worries. So And they're not quite yet into their monthly report, but they're having extreme progress already within a couple of sessions. And he had all of your guidelines that you already sent here that he was working with. So I suggest to every parent, before you go into any therapy, even if you don't have it in the court order, ask for their therapeutic plan. Know what are they doing, and then ask for monthly reports. And minimally, you can use those monthly reports to show that there is no progress. And many other therapists who presented to ISNAF have stated, if you don't have progress in 3 months, you need to move on. You're just throwing money out the door. So you have some measurable results for you to measure. And when you're engaging with a therapist, just set up that I'm going to need this in the beginning. And so Rick, who just came on camera, I don't know if I'm going to give Rick a moment to say something because he's right in the middle of a process and he's having a lot of great success with it, with the therapy, but there's still challenges in the family system. Rick, go ahead.
I I was just going to endorse, Brian's technique is it will work if all the points are followed, and enough of our points were followed to get us to this stage, but not all of them were followed, and that was just simply, my attorney couldn't get a lot of that over the finish line in front of the judge. But I believe there's enough structure in place, to get this. And Brian, we are with an LMFT who has been a court evaluator and has also done forensic work. So, and the best part is that my ex is the one who picked this person. I think it has more chance of succeeding than not succeeding. The question I was going to ask, I didn't put into the chat though, is that we couldn't get I forgot the terminology for it, when you want a reconvene with the judge in 6 months.
Status conference. They would
A status conference.
Or if you have a judge that's doing case management, which sometimes is, you have to apply for that. But otherwise, generally the two attorneys will have the ability to request an ad hoc case conference, even if there isn't a singular case management judge. So the therapist triggers the process by having a call with both attorneys saying, look, I think we're off plan. There's some issues here. So-and-so is not listening to me. Both parents are not listening to me. I think you guys need the parents to hear from a judge, and I'll write an interim report, and then you guys come back.
The challenge in this case is mom is self-represented and happens to work as a paralegal. But we're getting the reporting. So the judge already stated, because we had already talked about him asking for the status conference, and the judge said, no, you'll have to file another RFO. But he's getting the reporting and he has something to work with if he has to move forward.
Okay. They did write it in mediation, which in California you have to do anyways before the hearings. So at least we have the mediation written into it, and hopefully that, along with what you said, the therapist, helping to excel that and advance it would be enough to get back into court.
All right. So thank you, Rick. We're going to move on because we have a couple more questions and I want to be able to get to all of them. So next question, Steve, can you please just clarify the question very quickly?
Sure. Basically, I got, court order to get parenting time restarted immediately or quickly. That was 3 months ago. That was in January. The reunification therapist basically does not agree or kind of follow the court order. The judge made it clear that the child doesn't get to decide. And so he's wanting to spend all this time addressing, like you described earlier, Brian, this whack-a-mole. We got to address all these problems until parenting time can actually start. And no parenting time starting. There will be no parenting time starting because there will always be a problem. And I can't even get him to even update the judge, the no parenting time has started.
Okay, so I think your attorney needs to get his or her elbows out here because therapeutic processes are helped by parenting time. So in other words, therapist wants to take a series of issues sequentially, you solve a couple, that's great. Get some parenting time going. Build some
He's
happy memories. Bring it back into the therapeutic process.
yeah.
The therapist had a job to do, and you need a strategic therapeutic plan for how the therapist is going to achieve what the court referred within 6 months. And
Well,
that,
yeah, he would say it's not his job to enforce parenting time. That's the
well,
court's
then,
job.
then, you know, the clause we just looked at, that's the goal.
Mm-hmm.
So parenting time has to be happening, or else you're never going to get to the goal. So this therapist really doesn't know what he's doing, has to be replaced, or
Mm-hmm.
has to be you need a meeting with another therapist like Caitlin Burgess, who educates the therapist in so that they know what they're doing.
A quick question, because I understand Steve's circumstance. So, quick question. If this therapist is deeply entrenched, feeling highly knowledgeable, feeling that he's the expert and been named by the court, what can you do to get a therapist off your case?
Yeah.
You have to go to court, ask that the therapist be replaced, have a report like Caitlin's report, which was drafted with a view to getting that other therapist bounced, and have your attorney argue why this process is going nowhere because of a sequential process with whack-a-mole, no milestones, no strategic therapeutic plan. In other words, a non-evidence-based process.
Perhaps you could use Caitlin Burgess as your
Yeah.
expert witness on your case. There you go.
I would urge everybody, if you think there's a need to explain what systemic family therapy is, hire her. The report is written, so I can't imagine it would be very expensive for her to just explain a pre-existing non-case specific report to your court.
And Caitlin is in Northern California. And I suggest check her website out. She may even have that on her website. Extremely knowledgeable. Next question. Do you have any specific input, WRT capitals, navigating the favored parent having been diagnosed with borderline personality disorder?
Yeah, I was quickly thinking what the acronym might mean. I don't know, but I don't really get hung up on whether they have a personality disorder or parts of different
Oh,
personalities.
with regards to is
Oh,
W.
with regards to, okay. I don't really get hung up on that. I don't want to pathologize them, and I don't want them to use their own mental health diagnosis as an excuse. Rather, I just say everybody, no matter what their makeup, is responsible for their own behavior. And it's kind of it's irrelevant. Put it another way, if you're a borderline or a bipolar or a narcissist, and therefore you're very difficult to deal with in these circumstances, well, guess what? You have to work harder than the average parent to be a good co-parent. But it's not an excuse. You just need to work harder, get the job done, deliver the type of behavior that is expected of you in the child's best interest.
So thank you for that. And that being said, we had a presenter with ISNAF a couple of years ago who stated that oftentimes the targeted parents have a perception, well, if I can prove in court that they're a narcissist, they're a borderline, whatever, sociopath, That's going to be my answer. But that
No,
parent, that therapist presented that makes no sense. There is no judge who will take away a child because a parent is being diagnosed with a cluster B personality disorder. There's no science that shows that they don't make good parents. So caution. It's important for you to know that, understand the personality that you are dealing with so that you can function a little bit more successfully with that and not fall prey to it. But going out and spending all this money getting these diagnoses and getting the judge to see this is what they have serves you really nothing in PA cases. So, and I'm just going to let Brian say if that's not how you see that we've had professionals.
yeah, I absolutely steer away. That's wasted effort for that reason, exactly what Cindy said.
So with that, thank you all. And first of all, thank you, Brian. I'm going to invite everybody to put your little, under the reactions, put your little clapping hands up for Brian to see that. We're so grateful. And amazing presentation. This will be posted on our YouTube channel as soon as we get it edited. And you'll be all able to rewatch it. And as soon as I get Brian's, I'm going to say attachments, I will send it to everybody who joined our call today. And with that, I want to say thank you all for joining us. And I have a quote that I want to leave everybody with because I know and understand I'm in your shoes still today. This is the quote. Courage doesn't mean you don't get afraid. Courage means you don't let fear stop you. And that was from powerpositivity.com. You can find all kinds of great quotes on there. So we're going to be confronted with fear. Our therapists, our attorneys, the judges, the courts, the aligned parent, our children will find fear in it all. Inside of that, it's going to take courage. And courage does not exist without fear. And fear is false evidence appearing real. And keep working through your fear. There's answers, there's knowledge. We're here to support you. Brian's amazing. I invite everybody, visit his website. He has a ton of information on there, more than what I'm going to send you all. So with that, thank you all, and we'll look forward to seeing you next week, or excuse me, next month, or at the end of this month for our interactive meeting. So good night, everybody. Make it a great one.